Hey, welcome.
What do you know about law of partnership? Let's explore IT together.
The definition of partnership. Partnership Act 1961 defines as partnership. First of all, partnership is the relation between persons who have agreed to share the profits of business carried by all or any of them acting for all. Cooperative societies, registered statutory, and chartered companies are specifically excluded from the definition. Nature of partnership. In a partnership, the partners form an agreement to manage the profits as well as losses. The law of partnership is governed by the Partnership Act 1961. In Peninsular Malaysia, a partnership business must be registered under the Registration Business of Act 1965. In Sarawak, under the Sarawak Chapter 64, which is for business names, and Chapters 33, which is for business professionals and trade licensing. And in Sabah, under the Trade Licensing Ordinance number 16, 1948.
Formation of partnerships. A partnership can form with or without written agreement. Easier to form compared to a company. In general rule, everyone of legal capacity is capable of entering into a partnership agreement. Minor and adult can form a partnership. Principal, a minor could be in a partnership for any duration of time until he wanted to deceive firm. However, a minor cannot incur or be responsible for any contractual liability for the firm's debt. On reaching the age of majority, a minor can, if he wishes, discharge himself from all future debts of the firms by terminating the partnerships. If fails to repudiate the agreement, will be liable for the partnership debts.
Now we are going to see a case regarding partnership. William Jackson Company Malaya Limited with Wee Chan and Young Trading Company. 1964-30 Malaysia Law Journal 105. So, in this case, William Jackson Company Malaya Limited as a plaintiff and Wee Chan and Young Trading Company as a defendant. The William Jackson Company Malaya Limited, which is the plaintiff in the case, claimed against Wee Chan and Young Trading Company, which is the defendant in the case, the sum of $12,734.91 for goods sold and delivered by the plaintiff to the defendants. Chan and Young were sued as partners of the defendant's firm. But in this case, Young did not take any steps to defend. Chan is the only one who raised the defenses to prove that is not wrong, which seems too fishy. The defenses are that no firm by the name Chan and Young Trading Company ever existed, and that if such a company did exist, he was not a partner thereof. That he had not in any way represented or held himself out as partner of the said firm. Third, the goods bought from the plaintiff were for the personal use of Young, who was a minor, and that the partners were therefore not liable. Despite of the fact that the case shows only the held situation can explain the real scenario.
Okay, now we will move to the health. Chan was a partner of Young and Young Trading. Chan represented himself to be partner in the firm by approaching a salesman of the plaintiff to ask for credit facilities with the plaintiff company by registering the partnership with the Register of Business and by opening a banking account with his own money in the name of the partnership with the Bangkok Bank. Each mode of representation was sufficient to fix him with liability as partner of the firm. The fact that Young made use the goods bought from the plaintiff for his own purpose did not mean that the partnership and consequently the partner were not liable. Further, as Young had not taken any step after attaining the age of majority to repudiate the partnership, he was also liable as a partner of the firm.
There are 6 types of partners
in the law of partnership. Firstly, a general partner, who is a partner in the fullest sense. Secondly, an active partner, who actively participate in the management of the business and is known to the world as a partner. After that, a dormant partner, sometimes called as the sleeping partner, who takes no active part in the management but is nevertheless liable as a partner. Next, a quasi-partner, a person who in fact is not a partner but who is liable for debts of partnership as a consequence of holding out, that is causing people to believe he is a partner. At last, a salaried partner, commonly found in professional firms, may receive a fixed remuneration irrespective of profits plus a small percentage of profits. The firm is fully responsible for its acts.
Dissolution of partnership. First is by agreement. The partners mutually agree to dissolve the partnership at any time. Second is by operation of law. In section 34(1)(b), if the partnership is entered into to undertake certain tasks after the completion of that task. Third, death or bankruptcy. In section 35(1), provides that a partnership is dissolved by death or bankruptcy of any of the partner when otherwise provided for in the agreement. The fourth is by charging of shares. In section 35(2), a partner suffers his share of the partnership property to charge with payment of personal debt. Next, by supervening illegality. Section 36, if an event occurs which makes it unlawful for the business of the firm to carry on in the partnership. The sixth point is by court order. Section 37(b), permanent incapacity which affects the said partner ability to perform his duties.